Hello everyone, this is the video of legal studies and topic is criminal law. However, from our last few videos, I have been discussing the criminal law in India. So today in this video, I will discuss Criminal Procedure Code Part 2. Okay, so in this video, mainly today we focus on trial of an offense. So what is the procedure of trial in the case of an offense? Okay. However, before discussing the procedure, let us understand what is meaning of trial. Trial is the judicial adjudication to decide a person's guilt or innocence based on given evidence and arguments in the courtroom. Okay, so what does it mean that in the trial it is decided that the person who is standing in the dock whether he is guilty or not guilty. So this is the main purpose of trial. Okay. Now the next point that I will discuss, that is categories of criminal trial. So what are the categories of criminal trial? It is categorized or classified based on the nature or degree of offenses. So based on that, there are three categories. Okay, the first one is warrant trial, and under the warrant trial the kind of offenses those are included are severe in nature. Okay, second one is summon trial. Under the summon trial the kind of offenses those are included, that is minor in nature. Okay, and third one is summary trial. So it is petty crime for which punishment is almost zero, rather offender needs to pay the fine or else he may get 15 days or something like that imprisonment if he doesn't pay the fine, or maybe sometimes for a few days imprisonment, but this includes petty crimes only. Okay, however, for the better understanding, let's discuss what is meaning of warrant trial in detail. Okay, the offenses which are punishable with death or imprisonment for a term greater than 2 years are covered under the warrant trial. Got this point? So whatever the offenses are, if its punishment is more than 2 years, then it will be covered under warrant trial. Okay, the Criminal Procedure Code classifies the warrant trial into two categories. This is another interesting fact. Okay, the first category is warrant trial instituted upon a police report. In this case, the judicial magistrate may discharge the accused upon consideration of the police report and documents sent with it. Further, the magistrate essentially need not required to hear the prosecution or record the further evidence. So it is such kind of trial in which police officer registered the report and investigated that, made the charge sheet and presented to the magistrate. So in this case, if magistrate thinks that it is worth to initiate the trial, fine, or else if there is not proper evidence documented, then magistrate can record it and discharge the accused. So this is the first type of warrant trial. The second type of warrant trial is warrant trial instituted upon a complaint. In this case, the judicial magistrate is bound to hear the prosecution and record the evidence. See, in the first case, there was no prosecution, or no complaint. So, on that account, judicial magistrate is not bound to hear the prosecution. But in this case, when prosecution or victim filed a complaint, in this case, judicial magistrate is bound to record the evidence and to listen the prosecution. Okay, so these are the two types of warrant trial. However, whatever the case is, whether it is warrant trial instituted upon a police report or the warrant trial instituted upon a complaint, if there is no case discovered or proved, the accused is discharged, or if accused is not discharged, then the judicial magistrate holds a regular trial after framing the charge. Okay. Secondly, in respect of offences punishable with death, life imprisonment, or imprisonment for a term exceeding 7 years, the trial is conducted in a sessions court after being committed or forwarded to the court by a magistrate. Okay, so here we have discussed 2 points. The first one is saying simply that in the lack of evidence, judicial magistrate can discharge the accused. Okay, however, if he doesn't do so, then after the charge that is framed, trial will begin. Okay, so whatever the case is, whether the warrant trial instituted upon a police report or warrant trial instituted upon a complaint. So in both the conditions, if accused is not discharged, then trial will begin. So pay attention when trial will begin. Okay, this is the point where you need to pay attention, you need to understand it. Okay, and secondly, that I have discussed that if the offense or offenses which punishment is higher, in the sense death punishment, life imprisonment, or even the imprisonment for a term exceeding 7 years, in this case the only sessions court has the power to begin the trial. Judicial magistrate cannot do so. Okay, now come to the next point, that is summon trial. The case related to offences punishable with imprisonment of less than 2 years are kept under the category of summon trial. So the case is related to any offense which is not a warrant case, known as summon case. Okay, so in respect of summon case, there is as such no need to frame a charge, as we have seen that this is a smaller kind of offense, so it is not essentially required to frame a charge. In case of warrant case, it is essentially required. Pay attention. In fact, in this case, court gives the substance of the accusation, which is known as notice. The accused is being served a notice. Okay, when he appears before the court. However, based on given facts and evidence, the court has the power, pay attention, based on given facts and evidence, I repeat, the court has the power to convert a summon case into a warrant case. Okay, so it means if a case is filed under the summon case, but later on it is discovered that there is some serious crime committed, in that case, that summon case will be converted into warrant case. Especially when the magistrate thinks that it is in the interest of justice. Okay, but keep note of this, that a warrant case cannot be converted into summon case. Okay, it is not vice versa. I repeat, it is not vice versa. Okay, so now our next term is summary case. Okay, summary cases include only petty offences under which the length of the sentence is for a term not exceeding 3 months can be passed. So see how small it is, the offences. Usually in summary cases, a special summons is sent to the offender, okay, requiring him to either present in the court and defend himself or admit guilty and pay a fine by post. If a fine of rupees 200 or less is imposed in such trials, then the accused has no right of appeal. So got this point? Summary cases are those offences in which punishment is not more than 3 months, the first point. The second point that you need to pay attention is, if magistrate imposed the fine of 200 or less than that, then the accused has no right to appeal. Okay, so you have to pay that 200 rupees. Okay, so at this point in time you need to note the following points. The first one is, if the judge considers the materials insufficient for proceeding against the accused, the judge may discharge the accused by recording the reasons of doing so. Okay, so this is the first possibility. Okay, in the lack of evidence, proper evidence, judge can discharge the accused and he can keep the record of this. The second possibility is, in case where charge is read over and explained to the accused, and after this, if he, means accused, plead guilty, the magistrate shall record the plea and may convict him. However, if the accused pleads not guilty, rather demands trial, then trial begins. So what is the second possibility? Second possibility is when accused is standing in front of the magistrate or judge, he will explain the charge imposed on him. And after listening that, if accused accepts that charge or pleads guilty, then magistrate will convict him simply. But if he doesn't accept the charge, rather demands trial, then trial will begin. Okay, and the third possibility, that is, the trial begins only after the charge has been framed. So before the framing of charge, trial cannot be started. However, at this point in time, I would like to add one more information. I have been repeatedly using the word charge. But what does it mean? A charge is nothing but formulation of the accusation prepared against a person who is to face trial or for a specified offense. It sets out the offense that was allegedly committed. Okay, so got the meaning of charge? Now come to our next point, that is the steps when the trial begins. So now everything is done. What is next? Now actually trial will begin. So what are the steps? Once the trial will begin, then what is the procedure and how to proceed with? Okay, so here I will discuss a few steps that will help you to understand, isn't it? Okay, so the first step is recording of prosecution's evidence. Once the charge is framed, the prosecution is asked to examine his witnesses before the court, and it is called examination in chief. However, the accused has also right to cross-examine all the witnesses presented by the prosecution. Okay, it is the duty or obligation of prosecution to present all the witnesses, all the facts, evidence, and at the same time the accused will be also given opportunity to cross-examine all those witnesses presented by prosecution. So this is the first step, that is recording of prosecution's evidence. Once it is done, then the next step is a statement of accused. So it is also very important that accused must be asked. Okay, so his statement is also important. The court, if thinks it is necessary, can examine the accused at any stage of inquiry. And yes, there is no as such time limitation. It can be done at any point in time. Okay, or trial for the purpose of eliciting any explanation against incriminating circumstances. What does it mean? That the court will try to understand that the accused is not being forced, threatened, compelled to accept the guilt or the thing that shouldn't be allowed by the law. Okay, so self-incrimination is not allowed. Further, the examining the evidence of the prosecution, it is mandatory for the court to question the accused if it incriminates the accused. Again, so court will keep watching. Whatever the things going on, everything has to be done in a proper or in a friendly or in a honest way. So no pressure, no threatening, nothing should be involved in that. Okay, the purpose of this examination is to give the accused a reasonable opportunity. Pay attention. So accused must be given a reasonable opportunity to explain incriminating facts and circumstances in this case. The next step is defense evidence. What does it mean? In case, after all procedure including the cross-examination of witnesses presented by prosecution, examining the accused and hearing both the parties, the judge believes that there is no proper evidence that can prove that the accused has committed the offense. Then the judge is required to record the order of acquittal. So after the trial being done and rather prosecution couldn't prove the accused guilty, In that case, judge will record the acquittal of accused. But in case when the accused is not acquitted, pay attention. If he is acquitted, fine. But if he is not acquitted, in the absence of evidence, a defense must be entered and evidence adduced in its support. Okay? For this purpose, the defense may examine witnesses including the accused. Okay? The witnesses produced by the defense are cross-examined by the prosecution. So it is vice versa. The witnesses produced by the prosecution, defense has right to cross-examine, and the witnesses produced by the defense, then prosecution has the right to cross-examine, isn't it? Okay. However, hardly any accused persons prefer defense evidence in India. One of the major reasons for this is that in India, the burden is cast on the prosecution to prove the offense, and the degree of proof required in a criminal trial is proof beyond a reasonable doubt. This is quite a high standard that the prosecution must meet. Okay, simple allegation and accusation is not sufficient enough to prove someone guilty. It is not enough for the prosecution to assert that the accused has committed the offense. The judge must be convinced beyond the reasonable doubt that it was in fact the accused who committed the offense. Next step is, that is final argument. Once the witnesses cross-examination and all being done, then both the parties, prosecution and defense, will be asked to conclude their arguments. Okay? So, after that conclusion, the last step is judgment. Once the final arguments are done by the prosecutor as well as by the defense, the judge pronounces his judgment in the trial. So this is all about the trial of an offense. Okay? Hope you enjoyed the concept. It is very nice concept and procedure that is explained in CrPC. Okay? However, I would like to explain a few terms that I used repeatedly in this video. The first one is, that is the meaning of discharge and acquittal. I have discussed both the terms or used both the terms more often in this video. So let's understand what is meaning of discharge and acquittal. As per the provision of CrPC, an accused can be withdrawn from prosecution at any stage of trial with the permission of the court. So, if the accused is allowed to be withdrawn from prosecution prior to framing the charge, as we have discussed, trial will begin only after the framing of a charge. So, if charge is not framed, means in what condition charge cannot be framed? Means in the lack of evidence. So in that case, accused will be discharged. Pay attention. So if charge is not framed in the lack of evidence, then accused will be discharged. Okay? No accusation anymore. However, in case where such withdrawal is allowed after framing of charge, it is known as acquittal. What does it mean? That charge is framed, trial began, and then again, in the lack of proper evidence, or it is not proved that accused is guilty, if he is being acquitted, then that is known as acquittal. So this is the difference between discharge and acquittal. Discharge, remember, before the framing of charge, and acquittal means after the framing of charge, but condition is same. In both the conditions, why the accused relieved? As there was no proper evidence. Okay, so this is the concept of discharge and acquittal. So another term that I would also like to explain, that is plea bargaining. It is a nice concept in criminal law where parties have the opportunity to negotiate with each other, but that negotiation has to be bona fide. It's not like they can negotiate to any extent. Okay, and as well as all the offenses are not given such opportunities. Such negotiations is allowed only for a few crimes or offenses. So, plea bargaining refers to the provision of negotiations between the prosecution and the defendant, in which the defendant agrees to plead guilty. In return, he is awarded less harsh punishment than what is to be delivered normally. Okay, so if accused accepts his offense, his crime that he committed before trial even begin, then he will be punished, of course, but the degree of punishment or the quantum of punishment will be lesser than if it is done through the proper trial. Okay, so this is the concept of plea bargaining. I hope you must understood this, the whole process of the steps of trial in case of offenses or crime in India. Okay, in previous video I had discussed about the police investigation and also discussed the difference between investigation and inquiry. Okay, so what are the steps that police officers follow while investigating the case, and once police officer done his part, completed the investigation process, then he prepares the detailed report of his investigation and then he submit to the judicial magistrate, and then judicial magistrate, if thinks necessary, he also does some inquiry, and then the charge is framed to begin the trial. Okay, and after the trial begin, what are the steps that we have seen here in this video, isn't it? That is starting with the recording of prosecution's evidence, and then taking a statement of accused, and then defense evidence, and the final argument, and lastly the judgment. So this is what all about the offense trial or criminal trial in India. Okay, hope you must enjoyed the whole video. This is all for this video. See you in next video.